This Honorable Court of Appeals of Tennessee is in session.
Before we get started, I think we're still missing somebody. I'd see a box that's not filled out on my screen. Kevin, you see that?
I do not. Is it mine?
It's Mr. Hayes.
Oh, I don't, yeah, is Mr. Hayes presenting? He might just be in listening.
I'm not. I'm the sponsor for the Pro Hawk.
Okay, all right. Thank you, Mr. Hayes. Appreciate that and appreciate you being here for that. I
Yes,
just
sir.
noticed the box and wanted to clarify that. All right, thank you, gentlemen. Did you call the case, Angie? I was distracted. I'm sorry.
No, sir, not yet.
All right, go ahead and call the case, please.
Okay, Dolores C. Jones versus Smith and Nephew, Inc.
Thank you, and appreciate you calling the case, and thank you, counsel, for agreeing to participate via Zoom oral argument here today. I want to clarify a couple of things before we get started. First of all, I want to tell you that we will be applying the same rules and procedures as if we were standing in the courtroom here today, even though we're doing this by Zoom oral argument. Essentially, what that means is each side will get 15 minutes to make its oral argument. And if you are the appellant and have reserved oral argument or reserved rebuttal time, you'll get that rebuttal time. I also want to introduce our panel for today. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Having said all that, we will proceed with oral argument and we will hear from the appellant.
Good afternoon, Your Honors. Alex Davis for the appellant, Dolores Jones of Rutherford County.
All right, sir.
May it please the court and counsel. Your Honors, the parties agree that the only reason we are here today is Tennessee's Statute of Repose, TCA 2928-103, which, as the court is aware, provides for a 10-year limit on the filing of product liability claims under the Tennessee Product Liability Act. There are a few notable exceptions to this rule. First, exposure to asbestos, which is very similar to this case in that asbestos is a toxic substance, and the toxic substances that were shed into appellant's body were similarly toxic in that they were cobalt and chromium metal ions. Second, silicone gel breast implants, which involve implanted medical devices, similar to the implanted medical devices implanted into appellant's body. There's also an exception for minor children, and today I asked the court to consider two avenues for allowing this case to proceed despite the 10-year statute of repose. The first avenue that I asked the court to consider is the Canon against Absurdities, which, as applied to a latent disease case such as this one, allows the court to prohibit an unfortunate, unintended, and unreasonable result for a person like the appellant. The second is the doctrine of fraudulent concealment, which has been followed in several other states as applied to the statute of repose. Before I go into those two doctrines in detail, I do want to share a few brief facts about this case and why it is different. Total hip replacement is among the most common elective surgeries in America today. More than 400,000 people undergo a total hip replacement. Many of these patients, the device lasts a lifetime. It provides great relief from arthritis and other pain. Smith and Nephew's own experts emphasize that in 78% of total hip replacements, the devices last 25 years or longer. However, for a brief period of about a decade, ending around 2015, the medical device industry placed great emphasis on the sale and marketing of metal-on-metal hip implants. The entire construct is made of metal. This was premised on technology which was promising based on early...
Mr. Davis, let me ask you a couple of questions here, or at least one question. I understand You're giving us background here. And I'm looking at the order that the trial court entered in this matter. It doesn't contain any of what you're saying. And I'm not disputing what you're saying, but was this presented to the trial court, and did the trial court rely upon what you're saying?
This was contained in our pleadings, Your Honor. I'm happy to skip through it if you prefer.
I'm just
Sort of
trying
at
to
the end of
figure
the
out.
background component. It
I
was not
understand,
discussed.
and I appreciate the background, but what I'm trying to ascertain is, was this information that the trial court considered and relied upon when it granted the motion to dismiss?
It was considered in the pleadings, Your Honor. I can't speak to the trial court's mental processes and coming to the decision about the statute, but it is relevant, I think, to the fraudulent concealment doctrine and the latent injury doctrine.
Okay, all right. Just trying to clarify. Go ahead.
Absolutely. The device configuration in Mrs. Jones eventually became part of a mass tort proceeding that currently encompasses 800 cases. It is pending in the District of Maryland. Mrs. Jones, in January 2009, at the age of 59, had this device implanted in her body. She did not know that the system's components were not approved by the FDA and that they were not supposed to be used together. In fact, this device had been disapproved or denied by the FDA 3 different times before it was put in Mrs. Jones' body. There is no evidence that her surgeon knew about these denials. There is no evidence that any of this information was shared with any of her healthcare providers. Ultimately, after a 10-year period, Mrs. Jones started experiencing pain in her hip from metallosis. She went back to her initial surgeon, who informed her that she needed to have these components removed from her body immediately. 3 weeks later, in November of 2019, she did just that, and they were surgically removed in a process called a revision surgery, 10 years and 10 months after the initial implantation. She was noted to have a large pseudotumor caused by elevated levels of toxic metal in her body. These facts are not in dispute. This was at the time of her revision surgery. None of this is the fault of Mrs. Jones. In Tennessee, approximately half of the people with currently pending claims in state court against Smith and Nephew had revision surgeries after 10 years of implantation. The other half had claims related to surgeries less than 10 years after implantation. So we have a very arbitrary demarcator at this 10-year mark. Smith and Nephew never recalled this device like its competitors did because it was never approved in the first place. Smith and Nephew didn't inform the public, it didn't inform appellant or her treating physicians that it was silently withdrawing this product from all markets outside the United States. Now, the first of the 2 doctrines that I asked the court to consider is the latent disease exception. To be clear, this does not exist currently in Tennessee under the statute of repose. The legislature has not enacted it. I fully expect appellee to mention this. However, other states, including North Carolina, have allowed claims to proceed under the statute of repose. In particular, the higher case in the Fourth Circuit established, which is still good law today, North Carolina's latent disease exception. Florida is another jurisdiction that has made a similar exception, even though it has a tight 10-year statute of repose. The case in Florida is Pulmison Safety Equipment versus Barnes. I respectfully ask that this court allow plaintiff's case to proceed under the latent disease doctrine, allowing half of the people with claims against this company to proceed to trial and the other half to not proceed based on arbitrary 10-year demarcator, which is well followed in Tennessee law. We've cited a number of cases involving the Canon against Absurdities, which allows the court to go into statute of repose or any other statute for that matter, and look with more scrutiny at the result of that statute for the population affected.
Let me pose a question to you, Mr.
Obstacles?
Mr. Davis.
Yes,
Did-
Your Honor.
Was that theory presented to the trial court?
Yes, this is part of the latent injury exception.
Okay, again,
And I did argue that. It was a very short argument to the court.
I am looking at the order, and the order mentions nothing about that I can see.
Well, I didn't draft the order, as I recall. I did argue the case before the trial court. The latent injury exception was front and center. One of the reasons that we advanced along with the fraudulent concealment exception. So our briefing was very similar. Some of the cases that we've cited in our appellate brief go into more detail, the canon against absurdities. So I wish I had a better answer for you. That's about as well as I can do right now.
That's fine. I just wanted to make sure that we were both on the same page. Go ahead.
Yes, Your Honor. I want to point out that we acknowledge that the legislature has not acted here. The other two exceptions that are on the books, asbestos and silicone gel breast implants, were specifically carved out by the legislature. That has not happened here. However, that has not stopped other states from taking action despite legislative action or inaction. Appellant respectfully submits that the legislature cannot act every time there is a turn of the screw in an industry, especially one that is fast-paced and evolving like this one. I also acknowledge that there are certain cases where the legislature or the appellate system has declined to create additional exceptions. We respectfully believe that the facts are a little bit air liquide, are different from the case at bar. The case at bar here is very similar or silicone gel breast implant exceptions. Second, I asked the court to consider the doctrine of fraudulent concealment. There are very high revision rates for this device. Other cases have completely different facts compared to this one. The facts here are highly specific. In fact, they, to me at least, are very similar to the talcum powder ovarian cancer cases that have been litigated across the country over the last several years, where women used talcum powder for a period of decades and came down with ovarian cancer, typically after 15, 20, 25 years. The facts here are such that almost all of the failures of this device occur in the first 15 years. But sadly, especially for people like appellant, the failure often happens between the 9th, 10th, 11th, or 12th year. Through no fault of appellant, her device lasted 10 years and 10 months before it had to be surgically removed from her body. Finally, I will note that one of the things that Smith & Nephew focuses on in its briefing and its papers is a public policy argument about insurance liability and how the statute of repose needs to be in place so that it can assess its overall financial liabilities. That is not applicable here. We have a large multinational corporation. It has been analyzing that risk for years and years, and most of that risk comes from the states that are outside of the Tennessee statute of repose because they're from other states in the country. Unless there are other questions, I will pass the argument.
I do have one question for you, and that is this. What did you rely upon in asserting the fraudulent concealment exception? Was it simply your complaint, or were other pleadings filed, or what did the court have in front of it?
Just the complaint, Your Honor.
But the fraudulent concealment argument was specifically made to the court. Is that correct?
Yes, Your Honor.
Okay. All right. Thank you. We will hear from appellee.
Thank you, Your Honor. May it please the court. My name is Matt Lubazinski from Wyatt Turner & Combs here in Memphis, Tennessee, and I represent the appellee Smith & Nephew. I think at the outset, it makes sense to state what's not in dispute here. And what's not in dispute is that this is a products liability case and that the Tennessee Products Liability Act is at issue. And in that act, there is a statute of repose. And appellant does not argue that that statute is unclear. Appellant doesn't argue that that statute is in any way ambiguous. And it's clear that that statute, the statute of repose under the TPLA, only includes 3 specific exceptions. One is for minors, which is not at play here. One is for asbestos cases, also not at play here, and also breast implant cases, also not at play here. And appellant doesn't dispute any of that. Appellant tries to argue that his case is similar, her case is similar, but that's not what the statute says. And it's also clear, and it's not disputed, that the General Assembly, in enacting this statute over 40 years ago, and since that time, has not put in any other exceptions. It's just those exceptions. And also, it's not disputed that the appellant here filed her lawsuit outside of that 10-year statute of repose. In fact, it was nearly 12 years from the date of implantation until she filed. So she was clearly outside of the statute of repose, which the statute makes clear that that action is then barred fully, because there's no exception that applies. So what the appellant does here, even though all this is clear and that there's no exception, the appellant asks this court to do what the General Assembly hasn't done in over 40 years, and that's to judicially create either a fraudulent exception, a fraudulent concealment exception, or a latent injury exception. And that's not permitted, it's not warranted, it's not justified, and we think the decision of the trial court should be affirmed. And it's important to look at the difference between statutes of repose and statutes of limitations. Statutes of repose are substantive, and they extinguish both the right and the remedy. And what they do and how they're different from statute of limitations is they run from some event that's usually unrelated to the accrual of the cause of the action. And so therefore, like we have here, it's from the date that the product was purchased for use or consumption. And so what you often have in a statute of repose case is you have the actual cause of action being extinguished before there is even an injury, before the person even knows there's an injury. And it imposes this absolute time limit, and it's unrelated to accrual, and the Tennessee courts have stated that that means the discovery rule is inapplicable here, and it does not matter. And the Tennessee Supreme Court in Penley versus Honda, which we cited, has stated that these statutes of repose are absolute and unyielding, absolute and unyielding. And other courts recognize this in Tennessee, and they say it leads to harsh results. But these harsh results aren't absurd results. They're harsh results. And yeah, they're tough, but they are not absurd because they further the goal of the legislature. And here, the goal of the legislature in enacting this was to keep costs down for consumers. And it says that in the preamble, as noted by the Tennessee Supreme Court in Penley, and says we want to keep these costs down to consumers, and we think there's a crisis afoot with these products liability actions. And so what we're going to do is we're going to impose a 10-year statute of repose that you have to bring within those 10 years, within the 10 years, or else it's barred, except for in these 3 exceptions. And so if we look at the specific statute of repose here, which is at Tennessee Code Annotated 2928-103A and B, it says you have to file within 10 years from the date of first purchase for use or consumption. But what's important here is it enacted in 1978, and during that enactment, one legislature attempted to put in a fraudulent concealment exception. And this is told in the Dameron case, which was the Tennessee Court of Appeals case, where they said that got voted down by the legislature. So it didn't make it into the statute, the final statute. Then in 1979, there was an amendment made to allow for an exception for asbestos. And then in 1993, there was another exception made for breast implants. Since that time, there's been no further exceptions. And what the Supreme Court, Tennessee Supreme Court said is that these exceptions were quote unquote carefully carved out, which means the General Assembly, they looked at it and they said, these are the exceptions we want to have. This is what we want to allow for an exception to, otherwise everything else is barred. And again, it's designed to limit the time period for the products liability actions to provide for certainty for insurance and to keep consumer costs down. Now, it's also important to look at the language of the statute. The statute says, quote, in any event, an action must be brought within 10 years from the date on which the product was first purchased for use or consumption. And the Tennessee Supreme Court stated that the General Assembly's use of this language compels the conclusion that it intended for the 10-year repose period to be an absolute bar. And because the language is clear, and again, there's no dispute here that this language is clear. Because the language is clear, this court is not in a position to give the statute a construction that is not supported by the language. And that's exactly what the appellant is asking for here, is for this court to go outside the language that the General Assembly enacted on its own and add exceptions. And the reason why is, again, here in the complaint, in the amended complaint, if you look at in the record at page 30, paragraph 24 of the amended complaint, the left hip was implanted on January 12, 2009. And then if you look at page 1 of the record, it shows that the complaint itself was filed on November 10th, 2020. So again, that's nearly 12 years after the date of implantation. So again, well after the statute of repose, which requires it to be filed within 10 years. So what appellant has done is realizing there's no exception and that they're well outside the statute of repose, which requires the case to be dismissed as the trial court did. They asked the judiciary here to create not one, but 2 exceptions, one for latent injuries and one for fraudulent concealment. But here's the problem. The Tennessee Supreme Court, when it looked at whether they could do exceptions, now, albeit it was in the context of mental incompetency, but it looked to see first whether it can actually do any exceptions at all under this statute. And the Tennessee Supreme Court said, we will not rewrite the statute to insert other categories not intended by the General Assembly. They also said the language of the statute admits of no exception other than those expressly listed. And that's, again, only those 3: minors, asbestos, and breast implants. And it also said if there is an exception, it has to be found in the statute or in another statute that refers back to this statute. And it's not for the judiciary to create these. Also, which shows why these exceptions that appellant is asking for don't make sense here, is because we have in the statute, we have 2 exceptions. We have asbestos and we have breast implants. And what the court said is, and what we know is, it is a well-established canon of statutory construction that the mention of one subject in a statute means the exclusion of all other subjects. So we have here, the General Assembly says asbestos, breast implants, nothing else. That's it. And the statutory construction canon says we can't allow any others. But even further, there's other statute of repose statutes throughout Tennessee, and there's one for medical malpractice. And in that medical malpractice statute of repose, it specifically has an exception for fraudulent concealment. And what does that tell us? What that tells us that the General Assembly, when it wants to put in exceptions for fraudulent concealment, when it wants to put in exceptions, it puts it in, and it knows how to put them in. And here, it hasn't done that. And therefore, the judiciary can't go in and create these exceptions on their own. But what's interesting is the appellant comes back and says, and doesn't even deal with Penley, other than to say it was an ATV case with mental incompetency. But if you read the case, you can see that the Tennessee Supreme Court is trying to figure out how or if it can do exceptions under the statute. It doesn't even deal with that case or any of the other Tennessee cases we cited, which we cited a number of Tennessee cases. We also cited a number of federal district court cases and Sixth Circuit Court of Appeals cases, all addressing Tennessee law. But what the appellant says is, don't look at those. Let's go look at North Carolina and let's go look at Florida. And that's persuasive authority. The problem is, if you actually look at those cases, they're not persuasive authority. And the reason why they're not persuasive authority is for a couple of reasons. First, it's not persuasive authority because there's Tennessee law. We have the Penley case. Tennessee Supreme Court tells us exactly how to read and interpret this statute. And it says specifically, there are no other exceptions. We also have the other cases that I mentioned. But also, and appellant's counsel said, well, we should look at these because they have the same statute. Well, they don't have the same statute. In fact, the statutes are quite different. And in fact, if you look at the statutes, the Florida one and the North Carolina one don't have the exceptions that we have here in Tennessee. And in fact, that shows, again, based on the statutory construction canon, that there's no other exceptions. And so those show that it's not persuasive authority. And then if you look even closer at the actual cases that counsel cited, you have the Pulmason case from Florida. Well, the Pulmason case dealt with a repealed statute. That statute's not even in place anymore, and it was actually repealed when the Florida court looked at it at that time. And actually, the Florida statute today has exceptions for fraudulent concealment and latent injuries, which it didn't at the time, and which we don't have here, which is further evidence that it shouldn't be put in. But also, the Pulmason case was not just a repealed statute, but they found that the latent injury exception should be in there because it violated, the statute violated the Florida Constitution. Well, the problem here is, of course, we're dealing with Tennessee law and the Tennessee Constitution, and there are a number of cases that said that the statute of repose here is constitutional under both the United States Constitution and the Tennessee Constitution. So that case is totally inopposite. Then the higher case, which was the Fourth Circuit Court of Appeals, attempting to decide what the North Carolina courts or North Carolina would do with its statute of repose. So again, it's a federal court of appeals trying to figure out what the state court would do. And here we know what the state courts would do. Penley has told us that, and all the number of other cases that we've cited that, again, appellant has not addressed at all. And also in their reply, they cited to a case called Crespo versus McCullough to say that courts have allowed these exceptions. However, the Crespo case, which was jumping off the Callaway case, the Crespo case is not even pertinent here because it dealt in a real narrow issue where Crespo was relying on the prior precedent before Callaway came in and redid it, and it was found that that was a violation of due process and equal protection due to a sudden change in the law. Here, we don't have a sudden change in the law. In fact, this statute has been in the books for over 40 years. And again, the General Assembly has chosen over those 40 years not to put in an exception for fraudulent concealment or latent injuries. So what we have is no court in Tennessee or applying Tennessee law creating an exception for these. And we cited in our brief the Henry General Motors case, which was a Southern District of New York case. But what they said is we looked at the Tennessee circuit, we looked at the Tennessee Court of Appeals, we looked at the federal district courts, and we looked at the appeals courts, all that were applying this law. And those cases, all of those were unanimous, and they used the term unanimous, that there is no fraudulent concealment exception. And appellant here has not cited any, and appellant has not cited any that have a latent injury exception. And instead asked for this court to look to other cases in other jurisdictions to judicially do what the General Assembly has not done in over 43 years. And what makes sense is that it shouldn't add it because it's not in the statute. And again, the statute is clear. There are these other exceptions in the statute, which excludes other ones, and it goes against the clear intent of the legislature. And it would end up being the exception that swallows the rule. All of a sudden, you would open up all these cases to all these other cases for latent injuries or fraudulent concealment. So what we think is clear, and what the trial court found was clear, is that the statute was clear, the legislature was clear when they put in the statute, and that the law that this court, as well as the trial court, was bound by is clear. And that for those reasons, there's no exception for latent injuries, there's no exception for fraudulent concealment, and this does not lead to absurd results, as I stated before, because what it does is it puts a hard bar on statutes of, that's what statutes of repose do. And is it a harsh result? Yes, it's a harsh result, which is recognized by the courts, but it is not an absurd result. And with that, I'm finished, Your Honor.
Thank you. We will hear the appellant in rebuttal.
Thank you, Your Honor. I want to begin by providing a somewhat better answer to Judge Stafford's initial question about the background relevant to the case here. We did cite in our original brief in response to Smith and Nephew's motion to dismiss back in January of this year at page 6, details about how common and how reliable this procedure is today. And so I respectfully submit that that is relevant information because when we deal with a latent injury like this, again, very similar to the thousands and thousands of women who've used talcum powder and then been diagnosed with ovarian cancer, they are under an impression and an expectation that the product they are using is going to be safe and reliable. It's used by their neighbors, it's used by their friends, their coworkers. Only years later do they learn it is not safe or reliable and they're going to be injured. So wanted to provide that quick reference. A couple of points about the case law that Appellee mentions. Penley v. Honda Motor, that is not a latent injury case. That was a case involving an ATV wreck where a kid was driving uphill in an ATV and fell backwards. I don't think that that's a case that bars or is really applicable to the facts here in terms of the facts of that injury. Second, Appellee mentions that the goal of this statute was to keep costs down. And it's true. The legislature hasn't changed the law other than these 2 exceptions for 43 years. Maybe 43 years is long enough. Maybe after hundreds of people have been injured by a product that tends to last 10 to 15 years at the earliest, and really the defendant says it lasts 25 years and 3/4 of people, maybe it's time to reevaluate this. We respectfully present that the Canon against Absurdities is a way to do that under the latent injury exception, or alternatively, you don't need to use both, the fraudulent concealment doctrine as a way to open up just based on these specific facts. We're not going to create a can of worms here. I don't know of any other medical device like this one that's been implanted in so many people that was literally never approved by the FDA. The FDA is a highly regulated environment. This set of facts is not one that's going to repeat itself anytime soon. Finally, I did want to point to the Crespo case because I think that is a helpful reference by Appellee. Those cases were ones where the court said, even though the medical malpractice statute says a certain thing, we're going to do something different. They carved out an exception. It was not created by the legislature. Good example here. Thank you.
Right. Thank you, gentlemen. We appreciate your argument. We will take this matter under advisement and attempt to render an opinion, resolving it at the earliest time possible. We again appreciate you participating by Zoom oral argument. Ms. Angie, if you'll recess court to the call of the next case, please.
This honorable court is in recess until 3 p.m.